Do you see the beauty of it? My swift and terrible sword, and the earth will crack with the weight of your failure. When the dust settles, the only thing living in this world will be metal.
In 2015, the world reeled from attacks from enhanced individuals. It was not prepared for the tragedy in Sokovia. Under the leadership of Ultron, a robot army descended on the peaceful town of Novigrad, Sokovia, a province known for its wheat production and fine woolen goods. In a battle that pitted sibling against sibling, the otherwise sleepy town of Novigrad was levitated into the sky. Hundreds of thousands of Sokovians perished, and the world was forever changed. But in the wake of the tragedy, countries around the world rallied around a common cause. In response to the Sokovian tragedy and the supervillain Ultron, the world knew what it needed: to regulate enhanced individuals.
That is legally problematic. Hey Legal Eagles, it's time to think like a lawyer. Welcome back to Laws Broken, where an attorney destroys your favorite childhood movies by showing you how illegal everything is. Because everything is illegal. Today we are talking about the Sokkovia Accords from Captain America Civil War and the rest of the Avengers movies. We're going to pretend that it is an actual binding legal document and analyze it in far, far too much detail. For better or worse, in the wake of the Ultron disaster, countries worldwide through the United Nations signed the Sokkovia Accords. The Sokkovia Accords are a phone book-sized set of regulations aimed squarely at the Avengers personally and the organization S.H.I.E.L.D. It seeks to limit the so-called enhanced individuals, including registration components, monitoring components, and imprisonment components. I'm using the version of the Sokkovia Accords found at the Marvel Cinematic Universe fandom wiki, which you can find at the link below. Importantly, some of the provisions only apply to signatories of the Sokkovia Accords, while other provisions apply to all enhanced individuals whether they sign or not. This is quite the constitutional problem. So because this is obviously the most important legal analysis that I could possibly be doing right now, I put together 10 reasons why the Sokkovia Accords raise constitutional questions. But first I want to talk about the legal landscape in general, specifically whether the Sokkovia Accords would even be US law, and number two, what would the legal framework be for dealing with enhanced individuals in the absence of the Sokkovia Accords. So first, let's talk about the Accords in general. An accord is not a US law. I assume what the Marvel writers meant here is that the Sokkovia Accords are an international treaty that the US has signed. But just because 177 countries sign an agreement doesn't actually make it law in the United States. In the case of a treaty, the Senate has to approve the treaty by a 2/3 vote under Article 2, Section 2 of the Constitution. And there are tons of examples of treaties that the US has signed but not actually ratified. That includes the International Criminal Court Treaty, the Comprehensive Nuclear Test Ban Treaty, the Kyoto Protocol, and the Treaty of Versailles. Basically, the US is still in World War I. But for the sake of argument, let's assume that the US Senate has in fact ratified the Sokkovia Accords. It's more fun that way. In any event, even when treaties are ratified, they cannot violate the US Constitution. And in fact, this was an issue when the US adopted NATO because it was thought that the Mutual Defense Treaty would violate Congress's right to declare war. But before we get to analyzing the actual Sokkovia Accords themselves, we have to examine the status quo ex ante of US criminal law and tort law. Captain America chafes at the restrictions of the Sokkovia Accords, but it's not like in the absence of the Accords, he'd be allowed to operate domestically in the United States. Vigilantes are illegal. As we discussed in the video on the Dark Knight and all the laws that Batman broke, you can't just go around getting into fights, even for a good cause. The justification of self-defense generally doesn't apply when you intentionally put yourself in harm's way. And all of these enhanced individuals are using deadly force, which almost always carries with it a duty to retreat if you are able to do so. Of course, US law doesn't necessarily apply to the Avengers' actions in Sokovia and other foreign countries, but the fact of the matter is they are often operating domestically where US law does apply. Don't even get me started about issues of federalism, because Even if enhanced individuals were allowed under the Sokkovia Accords on the federal level, there's still all the state laws that prohibit their actions, and there's no way federal law would preempt garden variety state laws about criminal conduct. Now, you might argue that it seems like the Avengers and S.H.I.E.L.D. are operating as an arm of the government, essentially like mercenaries, which might have given them legal cover under the Battle of New York. But if that's so, that they're operating as an arm of the US government, that carries with it all kinds of constitutional protections, and that doesn't get them out of trouble. By the way, Tony Stark created Ultron, and effectively Ultron is his product entered into the stream of commerce, so Tony Stark is probably personally liable on a product's liability or negligence theory for all the damage that Ultron did. And since this is a Marvel movie, I put an after credits bonus scene about that topic at the end of this video. But the fact that the writers even considered any of these legal issues is why the adoption of the Sokkovia Accords is the best scene in the MCU.
Actually, the best scene in the MCU is the after-party from Age of Ultron, because of how effectively it uses a light, fun moment between the Avengers to reveal important information about the main characters while still being a funny scene.
Actually, the best scene in the MCU is the I'm Always Angry scene from the first Avengers, because it's just so iconic.
Well, actually, I'd say that the best scene in the MCU is the military propaganda montage in the original Captain America movie, because no other scene is so subversive, over the top, and hilarious all.
Yeah, this is my court. Objections overruled. But let's ignore those issues and let's talk about the 10 biggest problems with the US version of the Sokkovia Accords. So, in order of ascending constitutional infirmity, let's start with the compelled speech portion of the Sokkovia Accords. The Sokkovia Accords state, and I quote, "Any enhanced individual who agree to sign must register with the United Nations and provide biometric data such as fingerprints and DNA samples. Those with secret identities must reveal their legal names and true identities to the United Nations." This is a classic provision of compelled speech, some of which applies to signatories and some of which does not apply to signatories. But forcing individuals to give up their secret identities is the government compelling you to make a certain kind of speech.
I am Iron Man.
And if the First Amendment has a problem with the government restricting certain speech, you can imagine that it is doubly problematic if it forces individuals to make a certain kind of speech. For example, in the Supreme Court case of West Virginia School Board versus Barnett, the Supreme Court said that a school could not force students to stand and salute the flag. That was compelled speech. And in the same way that you can't force individuals to stand up and salute the flag, you can't force people to give up their secret identities and provide biometric data and fingerprints to the US government. Number 2, forced registration sounds a lot like internment. The Sokkovia Accords requires all enhanced individuals to at least register with the government, whether they are using their powers or not, which sounds a lot like the internment of the Japanese in World War II under Executive Order 9066 by President Roosevelt. That executive order was tested at the Supreme Court level in a court case called Korematsu, and the Supreme Court did not overrule the executive order, which interned the Japanese. Korematsu is still good law. That being said, I doubt the Supreme Court would rule the same way today, despite the fact that the ruling has never been overturned. But in any event, it seems like this is a clear violation of the Fourth and Fifth Amendment protections and requirement for due process. Number 3, monitoring of enhanced individuals. This seems like a clear Fourth Amendment problem. The Sokkovia Accords state, and I quote, "Those with innate powers must also wear tracking bracelets at all times." The problem is warrantless monitoring without probable cause just because someone is an enhanced individual would be a clear Fourth Amendment violation, a violation of the right to privacy. Being enhanced doesn't necessarily mean that you have probable cause to monitor them. And it would be crazy to have a blanket monitoring system that monitored everyone in the United States without probable cause. So it's very good that the US government has never had a program like that to monitor people without probable cause. The Sokkovia Accords also state that those with innate powers must submit to a power analysis, which will categorize their threat level and determine potential health risks. This feels like a huge violation of the right to privacy. The government can't just go around doing medical examinations of individuals just because it feels like it or because it's in the public interest. people have individual rights, specifically to protect them from this kind of invasive testing. And additionally, it would probably be a violation of Tony Stark's intellectual property. Even if he hasn't patented the Iron Man suit, it would probably be a trade secret, and the compelled power analysis would probably violate his IP rights to the suit that he created.
It's working. We're safe. America is secure. You want my property? You can't have it.
Number 4, the Second Amendment's individual right to bear arms. While this is still a huge point of controversy, in recent Supreme Court precedent in the District of Columbia versus Heller, the Supreme Court confirmed that the Second Amendment does provide an individual right to bear arms. So, what is the threshold for Iron Man, Falcon, and War Machine to be able to use their inventions that they created? Effectively, the Iron Man suits or the Falcon machinery are just arms that they have created, and certainly in some circumstances you are allowed an individual right to bear those arms. Now obviously individuals are not allowed to have military hardware, but the Sokkovia Accords don't make it clear where the individual right to bear arms starts and where the exclusion of military technology kicks in, and how that would apply to the individuals who are not innately enhanced but have created an enhanced suit for themselves.
I have successfully privatized world peace.
So given the makeup of the current Supreme Court and the deference shown to the individual right to bear arms under the Second Amendment, you can bet that the Sokkovia Accords probably run afoul of that right under the Constitution as well. Number 5, a violation of the freedom to associate. The Sokkovia Accords apply to all of the Avengers, even those who are not enhanced, effectively preventing them from being a member of this community or group. Now, the First Amendment is most famous for the individual right to freedom of speech, but the lesser known right of the First Amendment is the right to voluntarily associate. And the Sokkovia Accords prevent individuals from associating with the private organization called the Avengers and the private organization called SHIELD. Just because you are an enhanced individual doesn't mean you lack First Amendment rights to be a part of the group that you want to participate in. Number 6, violation of the freedom to travel. The Sokkovia Accords state, and I quote, "Any enhanced individuals who sign are prohibited from taking action in any country other than their own unless they are first given clearance by either that country's government or by a United Nations subcommittee."
Think of it this way. Your school has rules, right? Like, you can't draw on the walls. Well, your daddy went to Germany and drew on the walls with Captain America. And that was a violation of Article 16, Paragraph 3 of the Sokkovia Accords.
Now, the defined term taking action can be read very broadly. Would that prohibit all of the Avengers from setting foot in any particular country without getting the United Nations subcommittee to allow them to travel? And would it prevent them from traveling domestically in the United States? If it does, that's clearly a violation of the Privileges and Immunities Clause of the US Constitution, and not to mention a violation of various international laws that allow freedom of travel, particularly between the US and EU. I think that this is a poorly drafted statement, and it shows how important it is to define the terms that you're dealing with, because otherwise people will read them broadly when they're written broadly, and it can have unintended consequences. Which takes me to problem number 7, which is vagueness. There is a constitutional rule that requires criminal laws to state explicitly and definitively what conduct is punishable. Criminal laws that violate this requirement are said to be void on vagueness grounds. The vagueness doctrine is based on the due process clauses of the 5th and 14th Amendments to the Constitution. And I think that there's a big problem here in terms of what the enhanced individuals are being accused of, vague terms like taking action, vague terms as in what constitutes an enhanced individual itself. All of these are vagueness issues that are probably so vague as to run afoul of the due process clauses in the Constitution. That's why you need lawyers to draft these things, not comic book artists. But I digress. That takes me to issue number 8, which is imprisonment. The Sokkovia Accords effectively treat enhanced individuals who fail to comply with the Sokkovia Accords as enemy combatants. Now, it's one thing to send enemy combatants that are imprisoned in a foreign theater of war and send them to Guantanamo, but it's another thing entirely to send US citizens who were found in the United States to the equivalent of Guantanamo on some helicarrier some way. This is a clear due process violation. You can't just put people inside of a helicarrier with no lawyer, no arraignment, and no bail. That's clearly a Sixth Amendment violation to the right to counsel.
You're not going to put me in a prison. You're not going to put any of us in a prison.
And the other side of that coin is problem number 9, which is forced conscription into combat. The Sokkovia Accords appear to force certain enhanced individuals into fighting for the US government in certain times of war, effectively the draft. But it's another thing entirely to seek out certain individuals specifically and then force them into combat on behalf of the government. This seems like a clear violation of the 13th Amendment's prohibition against involuntary servitude. You might recall that we fought a real civil war to prevent involuntary servitude and slavery, and forcing enhanced individuals to fight for the government seems to run afoul of those prohibitions. Which takes me to problem number 10 and the biggest constitutional violation, the violation against habeus corpus. Habeus corpus is Latin for produce the body. And the Sokkovia Accords state, and I quote, "Any individuals who use their powers to break the law, including those who take part in extra-legal vigilante activities or are otherwise deemed to be a threat to the safety of the general public, may be detained indefinitely without trial. If an enhanced individual violates the accords or obstructs the actions of those enforcing the accords, they may likewise be arrested and detained indefinitely without trial." You might see where this is going, but simply detaining people indefinitely without trial is the classic constitutional problem. And in fact, just simply deeming someone a threat before they have committed any kind of offense is like a pre-crime prohibition, which again runs afoul of the Constitution. The writ of habeus corpus requires a person in custody to be brought before court, provided a lawyer if they can't afford one, and to be protected by the US Constitution. We fought the War of Independence to have the protections of the Constitution to prevent things like indefinite imprisonment for no reason whatsoever. This violates the Fourth Amendment, which protects people from arbitrary arrests. It violates the Fifth Amendment's protection against being deprived of life, liberty, or property without due process. And it violates the Sixth Amendment's right to counsel and a trial. There's actually very few parts of the Constitution that this part of the Sokkovia Accords don't actually violate. And that's why the lawyers are the real superheroes in the Marvel Universe. So in thinking about this Ultron Vision problem a little bit more, Tony created Vision. Vision is Tony's property, his chattel. So legally speaking, Vision is like Tony's dog.